Hello friends, welcome to our channel Khatri Stano. So this dictation is for the aspirants who are preparing for Rajasthan High Court. Be ready for the dictation without any stop. Capital punishment in India has a checkered history. In this chapter, the researcher would peep into the concept of punishment and its different theories, religious sanctions, legislative development, and present day crusade to deal with capital punishment. Para social interest in a civilized society lies in a peaceful and secure atmosphere which is governed by rule of law. A man possesses free choice to follow either good or evil. If he chooses evil, he is responsible for his choice, thereby inviting appropriate punishment. To impose just punishment is necessary as society cannot be denied the right of self preservation in a secured way. To dream for peaceful and orderly society, the inherent evils developed in individuals need to be eliminated for safety and comfort of others. It is indeed a melancholy commentary upon a civilized society for having failed to make a crime free living. A crusade to conquer evil, disturbing the moral fiber of society for preservation of justice, righteousness, human life, and to create a decent human society. The punishment being a perennial process has traveled in diverse directions leading towards the present day legal vessel where human life is more sacred than the time immemorial. What was punishment for a minor crime in yesteryears is today punishment for a major crime. Capital punishment is the highest punishment for any crime. Para, despite there being varied punishments for varied crimes from generation to generation, crime is prevalent in every society. The efficacy of punishment has been justified in every society with only exception that the harsh punishments have been more or less eliminated from the code and evil is treated in charity in most of the crimes. Even though not in toto, the barbarity breeds barbarity seems to have been understood and the human fight seems to be ruling the day where sentencing is viewed as a process of re-educating a criminal, thereby rehabilitating him so as to return him in the society as a responsible citizen. The holistic view of sentencing has yet to eliminate the severity in crimes which are bestial and treacherous tragedies deserving terrible condemnation and are so shocking to the human conscience that infliction of severe punishment becomes irresistible. The harshness and the human flight could not change the color of crimes. Para, there can be no attributes more important than the life and liberty of a citizen in a civilized society. Article 21 of the Constitution of India provides that no person shall be deprived of his life and liberty except in accordance with the procedure established by law. The imposition of death penalty on a convict is the procedure established by law which is subject to appeal and review. After exhausting all legal remedies, a convict has an option to seek remedy under constitutional scheme of pardon by moving a petition of mercy before the President of India or the Governor of a state as the case may be. Para. The power to pardon is a constitutional responsibility of great significance. The Constitution of India vests this power in the head of the state. Article 72 invests the President of India and Article 161 invests the governors to grant pardons, reprieves, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of any person. Article 72 confers upon the President power to grant pardons, reprieves, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of any person convicted of any offence enumerated in clause within bracket 1 to within bracket C to Article 72 within bracket 1. Article 72 within bracket 2 states that the power conferred by law on any officer of the armed forces for the purpose of suspending, remitting, or commuting a sentence passed by a court martial would not be affected by the power of the President contained in Article 72 within bracket 1 within bracket A. Article 72 within bracket 3 further provides that the power of the President to suspend, remit, or commute a sentence of death under Article 72 within bracket 1 within bracket C would not affect the power of the governor of a state to suspend, remit, or commute a sentence of death under any law for the time being in force. Likewise, Article 161 of the Constitution confers upon the governor of a state in respect of any offence against any law relating to a matter to which the executive power of the state extends. The power under Articles 72 and 161 of the Constitution is absolute and cannot be fettered by any statutory provision.